Mr. Martinez.
Could we turn the lights back on? And if I could get a couple of exhibits, please.
May we approach?
You will hear, or you will believe that you will hear the anchor's screams echoing in that bathroom. And you will see.
Facts not in evidence.
Overruled.
And you will see the slit through the throat. And you will see all of the stab wounds to Travis Alexander. And you will also see the shot to the right temple of his face. Mercifully, the violence came to an end with that shot. The violence that this individual here in court, guilted woman, Travis Alexander, didn't love her, didn't want her. That this woman ushered into that home. And you will come to know the severe emotional and mental suffering of this individual here that's depicted in Exhibit 661.
Objection is arguing an aggravating factor not proven.
Approach, please. One moment.
You will know the extreme and emotional and physical suffering of this individual here, this man, Travis Alexander, 30-year-old Travis Alexander, who had more tomorrows than he had yesterdays. This individual, this man, that told you opening statement and that she professed to love. She loved him so much that after she slaughtered him, she showed up at his memorial service. Showed up with the rest of his family and friends. She loved him so much that the grandmother...
Objection argumentative.
Overruled.
That they mentioned in the opening statement, the one that raised him. Well, after she killed him, she sent flowers to her. Oh, she loved him so much that what she did to him to show her love is set out in Exhibit 204, one of the injuries. And then took his body, dragged it down a hallway, and stuffed it into the shower. That's the love that she had for this individual. And that's how she showed it back on June 4th of 2008. But back in June 2008, Travis Alexander was living in Mesa, Arizona, East Mesa. And she wasn't even living in Arizona. She was living in Yreka, California, living with her grandparents. She had moved up there in April of 2008, and Travis Alexander was happy that she was gone, didn't have to deal with her, coming over and looking in the window of his house, peeking as he was making out with another girl. Coming into his house, he had a dog by the name of Napoleon and had a doggy door that wouldn't allow the sliding door to close. Coming in through that door, or using the garage code to come in while other people were there, turn the lights on and off. He was in Yreka back then and had moved in April of 2008. And while she was there in Yreka, they did telephone. They did call. They did send text messages. And yes, they even sent emails back and forth. And some of them are salacious. And you will see that it flows both ways. It doesn't just go one way. Rather than repeat them, you will see for yourself that she gave it as good as she got in terms of the salacious aspect.
Objection, argumentative.
Sustained.
She
Move to strike.
Granted. Jury will disregard.
She told him, for example, that she was shaving her pussy so that it could be nice and soft for him. That's what the type of text message that she sent. And that if he was good, well, that she would give him a blowjob and allow him to come on her face. That's what I was talking about when I said salacious. These text messages went back and forth. And they did have sort of a continuous, amorphous kind of relationship when she was in Wairika. And they talked to you about this 45-minute telephone call that they had. Yes, they did have a telephone conversation on May 10th, 2008, while she was in Wairika. And it was recorded, but she's the one that did the recording. No indication that ever he wanted to have that recorded, and they both...
Objection, argumentative.
Overruled.
Consistent with the facts.
Overruled.
And you will, according to them, you will hear this. But one of the things that you will also hear about that telephone is that she recorded that phone. It's called a helio phone. And it's, again, the conversation was reported on May 10th of 2008. What you will hear about that telephone is that she reported it stolen back on May 19th of 2008.
Objection, Your Honor. May we approach?
You may approach.
It's the new system I taught. Reported stolen to the Wairika Police Department back on May 19th of 2008. And now they're going to play it for you. This telephone that was reported stolen, that somehow now cover it. And you can take a look at not only, or listen to not only this conversation on this phone that was allegedly stolen, and she reported it stolen. Not only that, you're going to be able to get some text messages off of it. You're going to be able to see there were text messages that are going to be presented to you. This phone that she takes, where it's stolen, son that dad has not recovered, you can view. Well, she is living out there. And during that time, Travis Alexander was dating somebody by the name of Marie Hall. And he intended to take her to Cancun. And the defendant knew that. One of the things that happened is that in their conversation, that 45-minute telephone call, they talk about them getting together. And they talk about the sexual trysts that they will enjoy during that particular telephone call. But the overhanging that is that Travis Alexander is dating somebody else by the name of Marie Hall. Marie Hall wasn't particularly interested in Mr. Alexander, but she was dating him. And so during that time, toward the end of May 28th, the defendant was living with her grandparents on Pine Street in Wairika. And Wairika actually is close to the Oregon border. And she was living with them, and one of the things that she does is that she stages a burglary.
Objection, argumentative. Move to strike.
Overruled.
Of her grandparents' house. The grandparents called the police on May 28th, approximately 3:30 in the afternoon, and said, "Hey, somebody broke into our house." The police responded. They came out. And immediately they noticed that something wasn't right in their opinion. Something just wasn't right. There was money that was sitting around that wasn't taken. There were a bunch of guns that were there that weren't taken. There was television sets that weren't taken. All of that was there. And yet there was a break-in. One of the items that was taken in this burglary, and according to the defendant, she was interviewed by the police, she was left at about 1 o'clock. The police were called at 3:35. And before 1 p.m., nothing happened. She didn't see anything. And one of the things that was taken was a .25 caliber handgun. Remember Travis Alexander being shot in the face while he was shot in the face with a .25 caliber handgun. Then was making ready. Had a plan. She had a plan. It wasn't a spur of the moment thing. Another thing that
Objection, argumentative, move to strike.
Overruled.
Another thing that she did at the end of May is she contacted this old boyfriend that you've already heard about. This individual by the name of Daryl Brewer. Gave him a jingle, although they've been separated for quite some time. They actually were living together back in 2006, September of 2006, when the defendant took up with Travis Alexander. And she started to see Travis Alexander at the time that she was living with Daryl Brewer in a house in Palm Desert, California.
Objection mischaracterizes the evidence.
Overruled.
And they were together in that house. So she contacts him, this guy, and one of the things that she asks him is, hey, tells him, I'm taking a trip to Arizona to see a friend. She may or may not have mentioned Mesa, but she indicated she was going to take a trip. And one of the things that she needed was a little help from him. She wanted to borrow gas cans. And he said, sure, I have 2 gas cans. I have the red in color. They're 5-gallon cans. And yes, I do have them. And yes, you can borrow them. He doesn't remember exactly the date that this was, but it could have been the end of May, the first part of June. And so for her road trip, the defendant decides to contact this individual, get these 2 extra gas cans. The other thing that she does, even though she has an automobile, is she decides to rent a car for this trip. And Wairika does have deep places where you can actually rent a car. She didn't go there. Decided not to go there. It's a small town, Wairika. People know everybody's business.
Objection, argumentative, move to strike.
Overruled.
It's a very small town. And one of the things that she then decides to do is that instead of renting at this convenient location, she's going to drive approximately an hour and a half to Redding, California, which is south, to rent this automobile for her trip, where she's already talked to Daryl Brewer about getting 2 gas cans that he has, that are red in color. Each will accommodate 5 gallons worth of gas. And so she then decides to head on down, goes to Redding, California, at the airport there, and talks to a guy by the name of Colombo, Raphael Joe Colombo. He's the person who rented the car. And by now it's June 2nd. It's approximately 8 o'clock in the morning when she comes in to this Redding airport. And he says, remember her? Not only do I remember her, but except that the photographic lineup that you're showing me, he said to the police, that's the girl who points her out, the defendant. But she's got brown hair there. When she came to rent the car, she had blonde hair. And the defendant, you've seen most of the photographs, had blonde hair most of the time. He said, so the brown hair is different, but that's her. Another thing that he remembered is that when he tried to rent the car to her, he originally gave her a car that was red in color. The defendant said, no, I don't want the one that's red in color because that attracts attention of the police. And I don't want that. I want a different car. So he accommodated that and gave her a white Ford Focus for her to rent and take on this trip. June 2nd, 2008. And so she goes on her trip. Next morning, June 3rd, 2008. Early in the morning, she shows up at the house of Daryl Brewer. And ostensibly, she has told others that she was actually going to Salt Lake City. And that she was going to Salt Lake City to visit her boyfriend, a guy by the name of Ryan Burns, somebody that she had a relationship with.
Objection mischaracterizes the evidence.
Overruled.
It wasn't an extensive relationship, but it was a relation nonetheless. And according to him, when she came over, they did a lot of kissing and a lot of grinding. So there was a relationship there, however anybody wants to characterize it. So she stops at Daryl Brewer's house on the 3rd in the morning, sort of has breakfast or joins them for breakfast, and picks up the 2 5-gallon gas cans and continues on south, and then going the other way straight on over, for Reno perhaps, over to Salt Lake City, but continues on south, so that she then reaches Salinas, California, at about 3:30 in the afternoon of June 3rd, 2008. And she reaches that Walmart because she needs to make a purchase. She wants to buy something. And there's a receipt that shows this. It's about 3:30 in the afternoon. She buys another, amongst other things, she buys another 5-gallon gas can that accommodates. So now she has a capacity of 15 extra gallons. And if you do the math, 30 times 15, you can make, you'll know how much miles that's worth. So she now has 3 5-gallon gas cans on this truck, and she buys them in Salinas. Salinas, the Walmart there, has checked to see whether or not, because the defendant said, I took it back. I got a refund. Security department at Salinas, Walmart, checked every single register for that day, and the day after, every single one, no refund whatsoever, even though the defendant says she took it back. Then she gets down to Pasadena, and it's in the evening there. And in that evening, she fills up the car with gas, and you can also see that she buys extra gas. Gas can. And now, extra gas, she can make her way all the way through Arizona without ever stopping for gas. And no one will ever know she was here, at least because there is no purchase of gas. The rest of the time, she's using a debit card or a credit card, whatever it is, debit or credit. She's using a plastic to make purchases. Not a single purchase here in Arizona. Not a single purchase for gas. And her account is with Washington Mutual. And it shows there's no purchase whatsoever. It does show that there is that she filled the 3 gas cans in Salt Lake City, but no purchases whatsoever here in Arizona. One of the other things that we know about this car that she rented is that California requires that the cars have a license plate in both the front and the back of the cars. And hers, the white Ford Focus, did in fact have that. At some point along the way, the defendant removed it. And when she showed up, for example, in West Jordan, Utah, after visiting Brian Burns and after killing Travis Alexander, well, she was stopped by the police. Number one, because the front license plate had already been taken off. And the other thing is that one of the back.
Objection is characterized as a testimony. Move to strike.
Approach, please.
The officer stopped her in West Jordan, Utah, and the license plate in the back was upside down, even though this was a rental car that was maintained by budget. So she's making her way, because the evening in Pasadena, and she makes her way across the desert and arrives to see Travis Alexander early morning hours, June 4th, 2008. And according to her, she says, well, I was the person. He was the one that convinced me to come over. He's the one that told me that I should go visit him. Preparation for that, that's when she got the gas. So it's her statement that she was asked to show up. You know that when she showed up, she knew the code to Mr. Alexander's garage. We also know that she could have gone into the sliding glass door. We also know that Mr. Alexander did not have a gun. according to a statement that she made to this detective in a telephone call when she was trying to help the police solve this murder. Because she would get on the phone and talk to Esteban Flores, this detective, and tell him, you know, I want to help you. I want to help solve this murder. Find out. She told him Travis Alexander didn't have a gun at all. Didn't have one at all. He didn't. She brought it with her. A 25 caliber. That's the gun. And she shows up with the gun. She shows up with a knife. Because this killing happened in a bathroom that was upstairs. It didn't happen next to the kitchen. It didn't happen in any area where there was any proximity to any knife whatsoever. And during that time when she shows up at 4 o'clock in the morning, really don't know other than her statement of what happened. She's the same person who called the police and said that a cell phone was missing. That's not how it turns out for the trial. And so she arrives there, according to her statement, around 4 noon. The story that can be objectively verified is that about 1:30 or 1:40 in the afternoon, June 4th, 2008, they do enjoy a sexual tryst. And you were given graphic testimony, or you were given a graphic view of the photographs that were taken. And it seemed all so one-sided, except that, you know, there were also photographs of Mr. Alexander. And shall we say, he was in an interested state, as you will see. So they were both taking photographs of each other. And this is something that they did behind closed doors. It's not against the law. One of the things that they also told you was that, well, she was sort of like a kept woman. Somebody that he never acknowledged was his girlfriend. Well, when they were at a PPL convention in Oklahoma City, when the defendant was asked, are you dating Travis Alexander? No, I'm not. She would also deny it. So it was always a two-way street. And she was also Mormon. She had converted in November of 2006. She told somebody that she had converted both Mormon. And so at about 1:40 in the afternoon, some period of time, they engage in a sexual activity. And they take photographs. And they take photographs. The camera that purportedly belongs to Mr. Alexander. And it's purportedly a camera that's new, so that it would be foreign or new to the defendant if this was the first time that she saw it. And so thereafter, some time elapses, and we pick it up with the photographs again, because at 5:30, Mr. Alexander is in the shower. And Mr. Alexander, as most people do, is nude in the shower. And there's the defendant taking photographs of him with that same camera. And for about 10 minutes, she continues taking these photographs until the last photograph of him alive. He's sitting down. He's now nude, sitting down in the shower. She does, at that point, takes the knife, sticks it in his chest. That knife that's up on the second floor, because his room is on the second floor. The master bedroom is on the second floor. There are 2 other roommates that aren't there, but he has his own separate bathroom. And while he's sitting there, he stabs him in the chest. When you get stabbed, it hurts. But you don't die immediately. It's not that you get stabbed and you immediately die. You die from the loss of blood. And that takes time. It's a function of time. Because if there were medical intervention and you were sewn up, which is impossible in this case, but if you were sewn up, you wouldn't die. So it's a function of time. And during that time, Mr. Alexander was conscious. He knew the person he had just engaged in one of the most intimate acts that individuals can do had done this to him. What the scene shows is that there's blood everywhere. and there's blood everywhere, meaning that Mr. Alexander was ambulatory. Get up. Oh, he got up from that position. And he went over to the sink. And he leaned over that sink. As he leaned over that sink, she continued to stab him in the back over and over, almost in a little concentric circle on his back as he's bent over. And he's bleeding. Blood drops, which are passive, which is gravity coming down. There are also hypoglossal or smaller drops that indicate he's spitting out. And you see the sink all full of blood. And time is passing. He's going to die from wounds to the heart. That's fatal. But he's losing blood rapidly. And because of his excited state, in other words, he's conscious, it accelerates death. But that excitement is distress. And you are required to accept the verdicts, as you have already been told, a premeditated murder, as well as the suffering in this case. And as he stands there at some point, he crawls and walks down the hallway toward the bedroom. We've had this tryst, this sexual tryst. And they go down that way, he goes down that way, in the breach, where the linoleum ends, after it begins, to the bedroom. And yeah, went on over and did this. This, I mean, exhibit 202. Made sure he was dead. He was still making sounds at that point. Here. Time out. Then he dragged his bleeding body all the way back home, down the hallway, to the sink. And there, that gun, and shot him in the right temple. It's not done yet, though. Dragged him, and stuffed him into the shower, and began to clean up. I told you about the first set of photographs that involved the sexual encounter. I told you about the shower photographs. Well, there's a third set of photographs. Inadvertent photographs. The one that showed that she's the killer. Because this camera may have had a sensitive button on it to take photographs. No. But when the attack begins, you see the lights of the shower. You see movement, is what you see. After seeing Mr. Alexander sitting in the shower. And then, about a minute later, what you see is you see the defendant. Alexander is down. You see his head. You see him bleeding from the throat. The defendant. Inadvertent photograph that was taken upside down. In other words, the shutter was upside down and clipped the photograph. She continues to drag him. I mean Mr. Alexander, the man that she professes to love, and we're told that she loved, down the hallway. And another inadvertent photograph is taken. Oh, as she's going down, she also leaves a print. And there's blood around it. And puts him, stuffs him into that shower. But she does not lose her cool. She begins to clean up. One of the things that she gets is a glass, plastic glass. Don't know where she got it from, but she takes it. And maybe she turned the shower on. Maybe she got this glass full of water, put it on him. But she cleaned him up. And all, well, that's how the police found it. With this glass on top, in the shower. The other thing that she did is that there was clearly an attempt of water being thrown down the hallway that she had dragged it.
Objection argumentative, move to strike.
Oh, look. You see a box in the closet that has water damage and blood. And then you see this void You also know that the bedding where they had their last encounter, in that bedding, she took it. Before she took that bedding, she did something else. This camera that she was unfamiliar with, well, she went through and deleted the photographs of them involved in sexual activity, deleted the photographs of Mr. Alexander in the shower, and the photographs that were inadvertently taken, they were very, very dark and difficult to find, according to the person who actually went to look for them. And actually, it had to go through a process so that he could actually make out what was there. If you'll see the photograph, he actually deleted those 3 photographs also, and left everything on. As she's cleaning up before she leaves to the Orion Burns. And so she then grabbed the kit, grabbed the bedding, including whatever was on there, went downstairs, stuck it in the washing machine, and turned it on after having deleted all of those photographs. You'll hear that because of technology, because of the card that was there, the police were able to obtain these photographs showing her in the middle of killing or dragging Mr. Alexander's body. She then took off. Nothing in that fourth focus. She lied to Mr. Burns as to why she was late. As always, she lied. Told him, I got lost. That's where it was. Never indicating that she'd stopped to see Mr. Alexander. The other thing that she did is that she pretended to be concerned about Mr. Alexander. She sent him an email saying, hey, how are you doing, hon? You okay? Can you at least let me know how you're doing? She knew he was dead. She also got on the telephone and left him a message. Hey, you know, I'm sorry that I couldn't stop in Arizona to see you. So sorry. But you know, when you come up here in Eureka, we're going to have a good time. This was after she killed him. She's covering her tracks. And she also sent a text message. Apparently, Mr. Alexander had given her or had sold her a car, and she was paying him off. And the text message was, are you going? Something about, let me know if you're going to cash the check that I gave you. All the while, he was dead. So she then continued to try to help. And the police were saying things like he didn't have a gun, that sort of thing. Well, he was arrested. He was arrested. He was asked questions about this. And when Detective Flores asked her about it, she said, wasn't me. Not only was it not me, but I wasn't even there. I wasn't even there. Couldn't be me. I couldn't have done it. It could not have been me. Well, the detective continued, said, okay. Had another conversation within a day. She said, you know what? Made it up. Lie. Lied to you. You know, I was there. Yes, that's me. Yes, we did have sex, but I didn't kill him. It was actually a guy and a girl who broke in. These individuals that came in, they're the ones that actually killed him. I didn't do it. I didn't have anything to do with it. In fact, I'm almost a hero because when Travis was down moaning, I kept trying to get him to get up. And he wouldn't get up. And I was able to escape, push the girl aside, but not before I had a gun to my head, pulled the trigger, and I was saved. A miracle. That's the story that she told. Claims that she was able to run away. These 2 individuals let her get away. She took off and did not call anyone. It just took off. Well, they tell you, for example, that the factors is that she has post-traumatic stress disorder. And
She mischaracterizes the mitigating factor.
Approach, please.
stress disorder that is being set out for you as a possible or potential mitigating circumstance. But she has been diagnosed with this by an individual by the name of Richard Samuel. To use their phrase, somebody the defense handpicked, brought in to testify. And one of the things that he administered as part of this testing is something called the PDS. It's just the acronym for the test, in order to determine if you could diagnose her with post-traumatic stress disorder. And one of the things that you answer are questions. It's a self-reporting test. And he actually sat down with a legal pad, asked her the questions, and wrote down her responses. And with regard to question number 14, the defendant was asked, well, what is the event that started this post-traumatic stress disorder? He used the same, he being Samuel, to say that she was diagnosed with post-traumatic stress disorder. He said, the event that's stressful to me, that caused me to be diagnosed with post-traumatic stress disorder, is these two individuals.
Objection, Your Honor. Argumentative. Ms. Arias did not diagnose herself.
Overruled. You may continue.
It was these two individuals that came in. That's the event that is the basis for the diagnosis of post-traumatic stress disorder. A lie. That's what's the basis.
Objection, vouching.
Overruled.
That is the basis for Richard Samuel's PhD's diagnosis of post-traumatic stress disorder.
Objection mischaracterizes the testimony and argumentative. Move to strike.
Overruled.
This is an individual, a doctor that they, whatever term they used, went out to retain the come to testify. One of the other things that they talk to you, well, she's mentally ill. Talk about borderline personality disorder, which is number 8. That's located there. Well, a personality trait, that's what it says there, and Janine DeMarco.
Objection mischaracterizes what is written. Personality disorder.
Rephrase.
Number 8, we'll read it. Miss Arias has been diagnosed with borderline personality disorder. It's talking about personality. That's not a mental illness. So, for example,
Dr. DeMarte's conclusion.
Sustained.
well, Dr. DeMarco will talk to you about what a personality is. And a personality is not a mental illness. A personality, for example, and this is not to say that there's anybody here with that if somebody is a jerk about certain things, they will always be a jerk about certain things. It's not a mental illness, is what Janine DeMarte will tell you. It's not at all. It's just how they are. You don't take a pill for somebody who is an absolute jerk to make him a nice person. That's a personality is. And so when they talk to you about this borderline personality disorder, it is not a mental illness. So for example,
Argumentative and incorrect.
Overruled.
So, for example, in this particular case, what you have, and things that have been mentioned by the defense in their opening statement, is this relationship that the defendant had with Bobby Juarez. Well, one of the things that we know is that with Bobby Juarez, the defendant just couldn't let him go. When they broke up,
Objection, argumentative.
Sustained.
well, when they broke up, what the defendant would do is pick up the phone, call him, and when he would answer, she would hang up, even though they were broken up. She admitted she did that on a couple of occasions. And when she wanted to speak with him, what she did is that she initiated the conversation or the contact by telling him that she believed that the world was going to come to an end. And that's the reason why she was going to talk to him. And that's how the relationship started again with Mr. Juarez. And she had problems with him. She claims that, yes, as she told you, he was abusive towards her. Claims there was a call to 911, but nobody came. There's no record of that.
Objection mischaracterizes testimony.
Overruled.
Also tells you, with regard to Mr. Juarez, there was a problematic relationship. Part of the problem was that Mr. Juarez would go to the library, use the computer. One of the things that the defendant did when she saw him is after he had gone there, she went back to that library, sort of to check up on him to see what it was that he was doing, or what it was that, or who it was that he was talking to. This is a personality issue because with Matthew McCartney, they also talked to you about that. That relationship, they claim, well, it ended because Mr. McCartney was maybe involved with somebody else. What they didn't tell you is that the defendant, when she found out about it, she went and confronted or spoke with this woman, Bianca, wanting to find out what it was that was going on. And with Mr. Alexander, well, he was on a date, for example, with me, she would still be around when he would come back. If he was on the couch making out with somebody, she admits to being out there looking at him. That's her personality. It's not a mental illness. They talk to you about, well, you can't be swayed by sympathy in this particular case. And that the jury instructions tell you that as it applies to the victim impact statement. But on page 10, it tells you that you are not to be swayed by mere sympathy, not related to the evidence presented during the penalty phase. You consider your sympathy in the penalty phase. That's what it's telling you. So, there are also other items that they discuss. They talk to you about an individual who's going to come in. They said he. The only he that's involved in this that has diagnosed the defendant with domestic violence is a guy by the name of Robert Geffner out of San Diego. And this individual, Robert Geffner, out of San Diego, courts have listened to his testimony. And specifically in Texas, when he testified, the court there found that Mr. Geffner, well, he was nothing more than a hired gun. And in this case, didn't talk to anybody about anything other than the defendant. All of his statements, every opinion that he has, is based on what the defendant told him.
Objection argumentative and is incorrect. Move to strike.
Overruled.
They still, because as they told you, there is no documentation involving any incident of domestic violence whatsoever in this particular case. They indicated to you that the defendant has no prior criminal history. That's true, but you can consider that she lied to the police.
Objection vouching.
Overruled.
The defendant has admitted lying to the police. That is a crime. Just because it's an uncharged offense doesn't mean that you don't look at it.
Objection, Your Honor. Move for mistrial argumentative.
Approach, please. We're going to take the noon recess. Please be back at 1:45. 1:45. Please remember the admonition. Are there any questions? So the jury has left the courtroom. All right. Mr. Nurmi, you had an objection?
Yes, Your Honor. We objected to it. Moved to strike the comment related to after he talked about the truth of Ms. Arias having no prior criminal history. Mr. Martinez then went on to provide the jury with a speculation that, quote-unquote, lying to police is a criminal act, and she hasn't been charged with it. Mr. Martinez, in so doing, inserted a prior bad act into the proceedings that which Ms. Arias has not been given notice of. While this is consistent with the state's unconstitutional gamesmanship, it is, again, basis for a mistrial in the sense that now we have uncharged acts. He's claiming that she has no criminal history. These uncharged acts are somehow criminal acts for which there's been no notice, there's been no 404B hearing. Such evidence of that nature or argument of that nature is something that should not be in these proceedings. It should not have been something ever mentioned in an opening statement. It should be stricken and a mistrial should be granted.
Mr. Martinez.
As the court knows, the state is in a rebuttal posture. If they stand up and say that she has no criminal history, the state is entitled to rebut that. And one of the ways that we rebut it is by showing that the evidence that is presented in these proceedings, and there is no doubt, there's no issue that she lied to this detective, and that is a crime.
Your Honor, the other issue in terms of this mitigating factor is Mr. Martinez is saying, well, she lied after these events. Well, she had no prior criminal history prior to the event. They've known of these mitigating factors for months. They still, and Mr. Martinez's stating of the law is incorrect. He should know, by pursuant to Rule 15 and pursuant to Brady and pursuant to those authorities, that he has to provide evidence in rebuttal of any act or prior bad acts that he is going to use against Ms. Arias in these proceedings. He has failed to do so. He's failed to notice this farcical prior criminal activity as a prior bad act. It's not prior, but it hasn't been noticed, and he shouldn't be allowed to argue it or present it to the jury. It's reason enough for a mistrial at this point.
All right, I'm going to sustain the objection and order that the jury disregard the last argument. The motion for mistrial is denied. So, we also have some motions in limine. I don't know if the state's to call a witness this afternoon that would be impacted by these pending motions in limine.
Which one? I don't know which
Well,
one we're talking about.
Well, there are a number of them. The one regarding smuggling contraband, the one regarding changing counsel, the one regarding lacking remorse, and then there was another one regarding Dr. Horn.
I don't intend to address any of those with regard to Dr. Horn. My view is that they are, as you know, well, I filed a response, you know what I said, that they're arguing residual doubt. That's what they want to go and do. That's impermissible under the law at this particular point.
Is Dr. Horn testifying today?
No, he'll be testifying tomorrow.
Mr. Nermi?
I have not seen Mr. Martinez's response to the motions in limine, and so I do not understand the reasons why he believes we are asserting residual doubt. I would certainly take issue with that, but would like a chance to review his pleadings before the testimony tomorrow morning.
All right, we'll take it up tomorrow morning before we begin Dr. Horn's testimony. The other motions in limine, is the state objecting to the court granting any of the other motions?
As I said before, we're in a rebuttal posture. If it becomes an issue, I'll bring it up. At this point, I think it's premature. I don't intend to do it, but I don't know what they're going to bring up. So if they touch upon it, then I think I'm entitled to bring it up. If they don't, then I can't.
All right. So subject to the court hearing further argument, I'm going to grant the defendant's motions in limine previously noted regarding smuggling contraband, the change of counsel, and the threats against trial participants and lacking remorse.
Judge, I'm sorry. Last one? I couldn't hear.
Last one?
The one you just said.
Threats against trial participants and lacking remorse.
Okay.
Mr. Nermi.
Yes, Your Honor. The only thing I wanted to make record of is the state repeatedly talks about this posture of the rebuttal they are in as reason for why they are not disclosing evidence or why they feel like they cannot respond to some of these things. We take the consistent position that 13752, as well as Rule 15, and as well as Skipper versus South Carolina, said this is not about a rebuttal posture. Ms. Arias needs to know the evidence that the state is going to use against it. And at this point, as we've stood here after opening statements, she is yet unaware of all the state's evidence that they are going to present against her because of the posture the state has taken. So we just want to make record of that again, since he mentioned this rebuttal posture.
Mr. Martinez, anything you want to put on the record about that issue?
He has to be specific as to what he thinks I haven't given him. I can't address something when he's not being specific. If he's talking about Robert Gepner and his failure to turn over the raw data until October 10th, then obviously you're familiar with why I couldn't disclose everything there. If he's talking about the other witness from New Zealand, then obviously if I haven't been allowed to interview him, how can I rebut? Are they even going to use him? I know they didn't mention him in opening statement, and so I don't know if they're even going to use him. So for them to say, well, turn over something that you don't know about, I just don't think that I am in a rebuttal posture, and I'm unable to do it.
All right. Record's been made. We're at recess 1:45. All right. I've had two requests. The first request is the media has requested a copy of the preliminary instructions. It is court policy that preliminary instructions do not go on ISIS or the computer system until the end of trial. We're not going to do anything different. The parties have not agreed or stipulated to release those preliminary instructions. There's also been a request from the media to televise the opening statements. I've spoken with counsel. The defendant is objecting. I'm sustaining that objection for all the reasons previously stated on the record with regard to the media requests to televise the proceedings. All right, is there anything else?
No, that's correct, Your Honor. We would just, a couple of things, actually, I should say. As it relates to the issues the court just raised, I do want to make notion of the fact, because perhaps I heard you incorrectly when we were off the record discussing it. We would be objecting to the release of the preliminary jury instructions at any point in time before the verdict is reached. So that was our objection of what the court was saying just now is the policy is they will not be placed until the verdict is reached. Is that correct? Okay. So, Your Honor, that's all the record we have to make, and yes, we are objecting, as it relates to these issues, rather, but we are objecting to opening statements being broadcast.
Then, Judge, may we approach?
Yes, you may approach. Good afternoon, ladies and gentlemen. I sustained an objection to the state's last comment before the noon recess. You are to disregard that comment. I'm going to also draw your attention to page 11 of the preliminary instructions. Counsel say in opening statements is not evidence, nor is it argument. The purpose of an opening statement is to help you prepare for anticipated evidence. Mr. Martinez, you may continue.
Good afternoon. When we left off, we were talking about the proposed mitigation as set out in the jury instructions, same mitigation that was discussed with you by defense counsel and the and the second proposed mitigating circumstance advanced by the defendant was that she was just 27 years old when she committed the offense. You can look at the chronological age, but you also are to consider the sophistication of this individual. This is an individual that left home when she was 17 years old, an individual that went out into the world, if you will. According to them, they touted her as somebody who was working jobs to make sure that she could make ends meet and that she could live. So this is an individual that has had world experience. She has somebody who has worked, so somebody that has been involved in relationships of long duration. She has also been a parent or a pseudo-parent to somebody. So in all of that, you take a look at everything. You just don't take a look at the number. And 27 years old is not a child either.
Objection argumentative.
Sustained.
Move to strike.
Granted. Jury will disregard the last statement.
an individual reaches the age of majority at the age of 18. Those are the individuals that are allowed to go out and fight a war. She was 9 years young.
Objection, argumentative. Move to strike.
Overruled, the statement.
And also keep in mind when they talk about the 27 years old is that Travis Alexander, we're going to use that phraseology because you have to remember that you keep in mind or you consider all of the evidence, you just don't consider things in a vacuum. If we're going to use this language, Travis Alexander was just 30 years old.
Objection, Your Honor. Argumentative,
Sustained.
improper argument.
Sustained.
Move to strike. Move for mistrial.
Granted, jury will disregard.
One of the things you can consider is all of the facts that are presented in this case, including Mr. Alexander's age.
Objection, there's improper statement of the law. It's introducing an aggravating factor that doesn't exist.
Overruled, you may continue.
So when you talk about 27 years old, consider that not only in a chronological fashion, which is beyond the age of 18, but also in terms of the sophistication. There's a claim here under number 4 that the defendant suffered both physical and emotional abuse as a child. Well, they didn't tell you where that's going to come from, but you will find when the evidence is presented that the only person that alleges that is the defendant. And one of the things that you can consider, part of this is the defendant's character, propensity, history or record or circumstances of the offense. One of the things that you can consider in evaluating that is that the defendant is an individual who has a problem with the truth.
Objection, vouching.
Overruled.
When she was arrested, she lied to the police officers and indicated that she wasn't there. She also indicated that it was another individual, a male and female, that did it. And as part of this case, when she talked with a psychologist who found that she was suffering from PTSD, he based his finding that she had PTSD on this event of 2 individuals coming in and doing this sort of thing.
Objection, argumentative, mischaracterizes the testimony in the prior trial.
Overruled.
So this is an individual that when it behooves her, she will say whatever she needs to
Objection,
say.
argumentative,
Sustained.
Pendelli. Move to strike.
Granted.
And
Jury will
so
disregard.
this individual, this fact that they have here, keep in mind who's the person that's saying it. And you can consider their, as I said before, their character and their propensity when you are considering what this individual is telling you. You look at that, you don't consider it in a vacuum. The other one that they talked to you about, number 5, is she suffered both physical and emotional abuse during the relationship with Mr. Alexander. Again, as they've admitted, there's nothing to corroborate her word. It's just her word, this individual telling you that. An individual that we've already talked about as an issue with the truth.
Objection, vouching, argumentative.
As it relates to this particular case. Over and over, on a variety of circumstances as previously described to you, she has been less than truthful. Number 6 is the same thing. It's just a mirror, almost, of number 7. What they're talking about is the same thing. It's sort of double counting.
Objection, argumentative. Move to strike.
Well, take a look at number 5. It says, Ms. Arias suffered both physical and emotional abuse during her relationship with Mr. Alexander. The abusive nature of Ms. Arias' relationship, oh gee, what are they talking about? What kind of abuse?
Objection, argumentative.
Overruled.
Strike.
Overruled.
They're talking about the same thing. It's an abusive relationship and a physical...
Objection, argumentative.
Sustained.
Move to strike.
Yes, granted.
And with Mr. Alexander caused Ms. Arias to suffer extreme emotional stress at the time of the incident. A point to be made here. One of the things that these jury instructions tell you, and one of the things that you indicated during the jury selection process, is that when they're talking about the incident, they can talk about stress, they can talk about everything they want, but you are required to accept the fact that this has been a premeditated murder. A murder where, if we take a look at the elements, it has already been established that the defendant acted with premeditation, which means that he intended to kill another human being or knew she would kill another human being, and then it indicates that an act is not done with premeditation if it is the instant effect of sudden form of heat passion. None of that is here, and that is what you are to accept. Additionally, you are also required to accept, per the law, the aggravating, but the aggravating circumstance that was proved, which was that this was especially cruel. That the individual in this particular case, Travis Alexander, suffered either emotionally or physically as a result of her attack. The other aggravating factors that they talk to you about are number 9, the psychological makeup compared her ability to cope with the tumultuous relationship she had with Mr. Alexander. This 27-year-old who was involved with a man with a child, no indication that there were any problems there, also was involved in a previous relationship to that, what they term long-standing kind of relationship. And then there was also the Bobby Juarez relationship, the work that they talked about, she could have lived on her own, but this person, according to them, has a psychological makeup which impaired her ability to cope with a tumultuous relationship. We know that this individual, in terms of coping with the relationship, moved away to Wairika.
Argumentative motion, move to strike.
Overruled.
Moved to Wairika, and when she moved to Wairika, continued having this relationship with this individual. We also know that when she was here, and they were not together, this individual that's involved in this, or that they claim has a psychological makeup, would sit outside on at least one occasion and look at him while he was making out with another girl. This individual that when he breaks up with her, she moves closer. The same individual, as we've described, had this relationship with Bobby Juarez, where after they broke up, she would call him, hang up, she would call him and tell him that the world was coming to an end. And so, the last one that you have is that she is remorseful for her conduct. The only way that you will know that is by her telling you. This person that, as you know, like a police officer,
Objection, argumentative, move to strike.
Sustained.
well, was she truthful when she told the police officers that she wasn't there?
Objection, argumentative, move to strike. Motion for mistrial. Can we approach?
Motion for mistrial is denied. Objection sustained.
She did lie to the police officers, didn't she?
Objection, Your Honor. Again, argumentative,
Sustained.
motion to strike, and again, I'm going to
Sustained.
renew my motion for mistrial. It's the same objection.
Overruled.
She told the police officers that she wasn't there. You have photographs that show that she was. She told the police officers that it was a man and a woman who did it. She then said that she did it herself. She claimed that this telephone call this phone where she recorded this sex conversation, that it was lost and reported it lost to the police. Yet the conversation turns up here in court. That's the individual that's going to stand before you and indicate to you that she is remorseful. If you take a look at that, there are no mitigating circumstances.
Objection, argumentative, move to strike.
Overruled.
There are no mitigating circumstances in this case. None. And the only just punishment in this case, because of the crime, is death. Thank you.
Objection, improper argument is inconsistent with the law. Move to strike the last sentence.
Overruled.